5 seconds to go. Start. Mr. Rahul, learned advocate appearing on behalf of the state of Maharashtra, adopting the submissions made by the learned Attorney General for India, Ms. Geeta Luthra, and learned amicus curiae, Mr. Siddharth Dave, submitted that if the interpretation of Section 7 of the POCSO Act made by the High Court is accepted, the very object of the Act would be negated. Per contra, Mr. Siddharth Luthra, learned senior advocate appearing for the accused in both the cases, relied upon various provisions of the POCSO Act and of the IPC to submit that the offence under section 354 of IPC has a different connotation and different effect which could not be incorporated for the purpose of interpreting section 7 of the POCSO Act. According to him, the phrases sexual intent, touches and physical contact have not been defined in the POCSO Act. However, the explanation to section 11 states that any question which involves sexual intent shall be a question of fact, placing reliance on the decision of the Bombay High Court in the case of Bandhu versus State of Maharashtra in Criminal Appeal number 50 of 2060, decided on 17th October 2016. He submitted that the expression sexual intent cannot be confined to any predetermined format or structure. He further submitted that unlike POCSO Act, the IPC offence under section 354 uses the terms assault and criminal force. However, since sexual assault is defined under the POCSO Act, the definition of the words assault or criminal force contained in IPC cannot be imported into the POCSO Act, though permitted under section 2(2) of the POCSO Act, while fairly conceding that the first part of section 7 of the POCSO Act, which pertains to the act of touching the private parts of the child, may not require skin to skin contact. He, however, submitted that so far as the second part, that is, the other act with sexual intent, which involves physical contact without penetration, is concerned, the skin to skin contact is required to be proved by the prosecution. As regards the presumption under sections 29 and 30 of the POCSO Act, Mr. Luthra tried to draw an analogy from similar provisions contained in the NDPS Act and submitted that the presumption and reverse burden of proof on the accused makes it difficult for an accused to prove his innocence. Therefore, any interpretation other than the strict interpretation would expand the scope of the offence and would not further the constitutional objective of Article 21. In this regard, he has placed reliance on the decisions of this court in the case of Noor Aga versus State of Punjab and another, Sakshi versus Union of India and R. Kalyani versus Janak C. Mehta and others. Stop.